We have to move on to Officers of Parliament now, and I would like to introduce Dr. David McGee QC. David is the first person who has written in this gap, which I found, between the theory and the practice of public law, because he wrote the authoritative book on parliamentary law and practice in New Zealand. It's called Parliamentary Practice in New Zealand, and it's a fabulous book. And he did that while he was working full-time as the former Clerk of the House of Representatives. Now, the book sets out the importance of the Clerk. Essentially, the Clerk of the House has the role of being principal advisor to the Speaker, and we had the Speaker here, but also to members of Parliament, and we've had many of those here today. So I was inspired by David, and I went to see him. And I just want to be very clear that had David not agreed to read my chapters. Now, I need to be very clear about this. All the mistakes are mine. And when he wrote Parliamentary Practice in New Zealand, he spent many, many more years than I did getting that document right. And he warned me to go slower, but I felt like an iceberg on a hot day. I knew that if I didn't finish it, I would never finish it, David. And I want to thank you for encouraging me. If you hadn't agreed to look at my chapters and tell me that they weren't rubbish, I think I would have stopped, because nobody knew what a public law toolbox was, and everybody thought it was a pretty dumb idea, actually. And so it's interesting today to hear people say that it might be constructive and it might be helpful and it might facilitate a conversation. So I think back to what the Chief Human Rights Commissioner says about affecting change. So I want to pay tribute to David. Dr. David McGee is now an Ombudsman. The Ombudsman is really the first generic complaints officer. They're an officer of Parliament. They have way too much work. I am worried that the book has doubled their workload. I'm joking. It is really important that people understand how important this particular officer of Parliament is. And David, we're very grateful for you being here. You know a lot about public law, and the reason why I approached you was not only that you'd done it at the coalface, you had written this magnum opus, so I knew you knew that it could be done, but also because there are not many people that I can talk about public law with, and I felt out of respect for your abilities that you knew a lot more about public law than me. So can I invite Dr. David McGee QC to take the stand and talk to you about the Ombudsman.
Oh, thank you for that very generous introduction. And I am here in my Ombudsman capacity, not in wearing my old hat, because in my Ombudsman capacity I drive the ambulance at the bottom of the cliff. In contradistinction to some of the agencies you just heard from, the Ombudsman is exclusively a complaints body. In fact, as Mai has said, it's the granddaddy of complaints bodies in New Zealand. The Ombudsman is an office of last resort under the Ombudsman Act, in that it takes complaints about administrative action, both at central and local government level, for which there's no other statutory means of review, and which can't be cleared up by going to the agency first and asking the agency to redress it. And that last resort principle is applied very strictly as far as the Ombudsman is concerned. The issue will not be picked up if there is a means of statutory review of the action complained of. It will not be picked up if the person concerned hasn't gone to the agency first. The Ombudsmen are also the statutory reviewers of complaints arising under the official information legislation. My work, I estimate, is divided about 60-40 in favour of the Ombudsman, traditional Ombudsman jurisdiction as opposed to the official information, but it's a pretty even spread. The Ombudsman Act jurisdiction is extrajudicial, it's non-binding, and it's a form of administrative justice. The Official Information Act jurisdiction, on the other hand, is legally binding, and it's a form of adjudication. The Ombudsman was created 50 years ago this year, celebrating the 50th anniversary of the creation of the Ombudsman in New Zealand. And it was the first time in an English-speaking country that the Ombudsman concept had been created. existed in Scandinavia before. Because of that, and I think also because of the active way in which the idea was promoted by the first Ombudsman, Sir Guy Pauls, New Zealand's initiative has been very important internationally, very influential, to such an extent that the idea is spread all over the world, and all self-respecting countries these days have an ombudsman. But when the Ombudsman was first created back in 1962, public law as a concept didn't exist. May wouldn't have been able to write a public law toolbox book, or if she did, it would have been a very short one. In those days, we called it administrative law. It was invariably referred to in that form, and it was moribund. Where it operated at all, it was highly formalistic. A major motivation, indeed, for establishing the Ombudsman's office as an administrative justice system adjunct was to supply that legal gap. Now that changed very quickly, both substantively, with the judiciary taking a much more expansive view of the circumstances in which judicial control of administrative action should arise, and procedurally, with a simplified form of review, judicial review being created to replace the previous highly complex prerogative writs and prerogative orders. Given these developments in public law occurring within a decade of the creation of the Ombudsman, was the Ombudsman created to solve a problem that no longer existed? Well, not on the evidence of the figures. In the first full year of the existence of the Office of the Ombudsman dealt with just over 300 complaints. Last year, the Ombudsman's office dealt with over 7,000 complaints, plus over 1,000 complaints in regard to the official information jurisdiction, which of course is a jurisdiction that didn't exist in 1962. So although the Ombudsman is positioned at the bottom of the cliff, and judicial review of administrative action is a more potent force than it was in 1962, the Ombudsman is still resorted to on what, to my finding when I joined the office, is still a fairly prodigious basis. Why is this so? Well, I think one reason is it's cheap. There aren't any charges for resorting to the Ombudsman. In addition, and I say this advisedly in this company, most complainants to the Office of the Ombudsman generally neither need nor employ representation. These factors are allied to a major difference between Ombudsman inquiry and legal proceedings. The Ombudsman operates inquisitorially rather than adversarially. The process of investigation doesn't depend upon the initiative of the parties to it. The process is driven by the Ombudsman, and it goes where the Ombudsman wishes it to go. It can differ depending upon the circumstances of the matter. It can be highly formal, including taking evidence on oath, although not in my experience, or very informal, a phone call. The outcomes can be equally varied. A report to Parliament, as I did last year with a complaint into how a school handled episodes of bullying, or a quiet compromising of a problem that is given no publicity at all. So the modus operandi of the Ombudsman and the modus operandi of a court are quite different. I think I just want to contrast the two. While the legal context in which an administrative action takes place is always important to an ombudsman, and indeed it may be critical to the outcome of a particular inquiry, it's never determinative. The ombudsman's administrative justice remit doesn't necessarily end just because the law ends. An outcome may be mandated by legislation, and that takes care of things as far as the law is concerned, but it may still, in its individual operation, be unreasonable. And an ombudsman's entitled to say so, although it wouldn't be done very likely. But an ombudsman isn't a judge. An ombudsman can't make a definitive finding on a question of law. If one wishes for that, one goes to a court. And that's an inevitable concomitant, it seems to me, of the ombudsman's broad jurisdiction to make judgments on administrative reasonableness. The ombudsman and the court operate on different planes. I thought I'd just finish by saying that while I think the modus operandi of the ombudsman is one of its advantages, And a strength of the way in which the Ombudsman works in the administrative justice system, it may not be quite so appropriate a modus operandi in the Ombudsman's official information role. In regard to official information, the Ombudsman's determining legal rights, the right of access to official information held by an agency. It's legitimate, it seems to me, to expect in that role that the development from the Ombudsman of certain principles, indeed a jurisprudence, from which one can learn, draw conclusions and make predictions for outcomes in the future. Now these are there, but you have to look very closely to find them. They're not overt, and they've really been underdeveloped. I think one of the challenges for the Ombudsman in the future, possibly arising from the review being carried out by the Law Commission, is to make that more overt and more conscious a development in the future. Thank you.